Hello there. Nice to see ya. Taking a case to trial can be time-consuming and expensive. A lot of preparation goes into preparing a case for trial by attorneys, parties, and government employees. There are all kinds of expenses, including attorney's fees, filing fees, fees for experts, and discovery costs. A courtroom will have to be set aside for a trial which may last a day to several weeks. A judge will be needed to preside at that trial for whatever period of time is required. Other court personnel, including someone from the clerk of court's office, a court reporter, and bailiffs will also have to attend. All this costs litigants and taxpayers money and requires bureaucratic attention to planning of a trial. In an effort to save time and money, arbitration has been made available in many instances in lieu of trials. In an arbitration proceeding, either a single arbitrator or a board of arbitrators sit as judge and jury in deciding a case. State law and state and local rules of civil procedure will specify the circumstances under which an arbitration hearing will be held and the process to be followed for that arbitration. Generally, arbitration will be required in cases under a specific dollar amount. In other words, arbitration will be required in cases which have been determined by the state or county government to involve a small dollar amount in controversy. That dollar amount may be $10,000, $25,000, or $75,000, or even some other amount. It is believed that smaller cases are less complex and therefore can be resolved by the more cost-effective and less time-consuming procedure involving arbitration. Whether the rules require a single arbitrator or multiple arbitrators, an arbitration hearing can usually be scheduled for a time and place much quicker than a trial in a courthouse. Arbitrators, attorneys who practice law within a county, have a more flexible schedule than judges and court personnel. Arbitration hearings can be held in any conference room, meaning that a location for an arbitration can be scheduled for virtually any time. Furthermore, prep time for the arbitration is not as significant as the amount of time required to prepare for trial. Finally, the procedures in arbitration are not as strict as procedures which must be followed in a trial before a judge and jury. Arbitration can also be used in larger cases if the parties are in agreement or if the parties are bound to go to arbitration under the terms of a contract. In any event, arbitration has become a favorite form of ADR, Alternative Dispute Resolution. Remember, arbitration procedures are governed by statutes and in particular by state and local rules. So adhere to your instructor's mantra. Read the rules, read the rules, read the rules. There you are. Now go to it.